we have come to the Q&A session. I would like to invite all the panelists, Datin Anit, Datuk Hassan, and also Miss Chin to on their videos and also their audio. Okay, we have actually a lot of questions from the participants today. It shows that the webinar today is very, very interesting. All right. The first questions, I think this one is for Datin Ani. Many doctors are unable to defend themselves when medical negligence or complaint arises as there was no proper or complete documentation in the medical record. Please give your opinion. And also there is a few also was asking about documentation and medical record, especially because sometimes it has been illustrated through the webinar that it's very, very important. Can you please advise us on this matter? I think you can on your video. Maybe during the lecture only it doesn't really work. I hope that you can see your beautiful face again.
No, I'm trying to turn it on, but I think my Wi-Fi is having this issue. So I'm going to turn it off, keep it off for now, and I'll turn it on the minute I can switch to hotspot.
All right, okay.
Firstly, about when you are in MOH, I would definitely say that MOH covers you for medical negligence cases. But what we were talking about was, and Dato' Hassan also alluded in his lecture, was if there is a complaint to the medical council, then there is no MOH coverage per se. That's why, and there's no assistance of legal counsel made available to you. So that's why we would suggest that even despite being in the MOH, it would be good to take professional indemnity policy that covers you for such occasions. And there are many in the market now. You definitely have got an array to choose from, and specifically those within the MOH. Would you like to add to that?
Yeah, I've seen a few people in MOH were called up by MMC Council for their cases, and the pengarah and the MOH says that they are on their own. So they have to go and find their own legal advisor or legal aid to come with them when they go to the council. In contrast, if you're in private practice, you have medical indemnity. Your medical indemnity insurers will assist you, will tell you what's going to happen, come with you to the MMC meeting and things like that. I've done that, I've gone through that. And my Zwara, who's now the High Court judge in Malacca, she assisted me in all these things, which was quite helpful, because to be called to an MMC and have no idea how the things are going to be done, you're completely clueless. It's like going to the court for the first time with nobody telling you what's going to happen. So for MMC cases, for doctors in MOH, they're completely lost, because even the pengarah cannot help you because he has never been there before.
All right. About the medical records and documentation, what is the best chronology? You know, sometimes we tend to, I think in practice, Dato', you know, sometimes we tend to slack about this, and we know that it's actually a legal document, but sometimes we just cannot help it. Do you have any suggestion or from any of the panelists who would like to comment on that?
Sorry. I know in emergencies, a lot of us do not have time to write down. It is okay during the emergencies, during critical periods, do what you have to do. Come back later and write. That is very important. A lot of people forget to write. And then the sad part is that the patient gets transferred to a different hospital. Then you completely lose that opportunity to document. It's okay to come back and write, and you can write down post resuscitation or post whatever you've done in an emergency, and you write down. And I always take a picture of what I've written down, because a lot of times things get lost, especially anesthetic charts.
It's true. And then also when the litigation came to you, it's like years after that. It's not immediately. So any
I can just
advice?
add something on that, and maybe this might capture that. I think my fellow litigators will share this view. Good case recording, good case. So-so case recording, so-so chances of defending yourself. No records, no case. Right? And I think if that's the mantra that doctors develop in terms of prioritizing records, what Dato Hassan says is spot on. You can do retrospective notes. Make sure that you write down the date and time you're doing it. Because if, as you say, Prof. Azarina, people realize this only a few years later and do retrospective notes a few years later, it is not going to have any weight. You know, I believe one doctor once in the same day had different handwriting for the same patient, and from the other side of the table we could see that he had used a different pen. Those were the days when it was before electronic records, and we said if we can see the different pen use, anybody else can see it as well. You know, so these are the small things. Someone has quickly written in a little thing, just the color of the pen can change the level of the case.
And just to remind you all that if you did not record down expert witnesses and things like that, will go back to the nursing notes and look. Nursing notes are very, very good compared to doctor's notes. And if you did not write down, they go to nursing notes. It's very good. I can extract things out. But a lot of times, nursing notes do not reflect what actually happens.
I agree,
That's
Dato'.
the dangerous part.
I agree. In fact, that case study that I gave during my presentation about the endocrine surgeon, the clocking of the temperature, blood pressure was done by the nurse. That was done in the presence of the doctor, and that's what saved the doctor, that he had done some physical examination.
That shows how important the documentation is. We wish all the hospital in Malaysia will have an electronic documentation, but one day, but at the moment, I think it's still a long way to go. All right, so we go to the next question. The question is, if a house officer commits a medical error, are the medical officer or specialist of the patient liable to it? Any of the panelists would like to answer this question?
I can try. Okay. There is a specific case about that. I can't remember the name of the case. A house officer is judged according to the house officer's standard, what he can do. And if he cannot do that, he has to refer to his medical officer. And if his medical officer will have to work according to his medical officer's standard, and if he thinks that there's something that is not right, he has to refer to a specialist or consultant. So that is how the line goes up. There is a case specific for this. A child comes in and they need to put an umbilical catheter to measure PO2 to prevent retrolental fibroplasia. Now it was put in by the house officer. Apparently it went into the venous rather than the arterial. That is the job of the house officer to put in, and he put in. But the medical officer who reviewed the X-ray knew something was not right. He did not escalate it. So the house officer, because he's a provisional registrant, was absolved. But the medical officer, until the consultants, they are all responsible for it. Therefore, they are all will be held responsible for it. I can't remember the case, but I do know the case is quite an important case here.
If I can add to that, at the end of the day, again, there's a perception of, and exactly what Dr. Hassan says, they look at the role, but being the government, they're vicariously liable for all the whole team that is in there. So this is when there's an allocation of blame within the team. But from the patient's perspective, they don't care whether it was a houseman or a MO or a consultant. If a mistake is made, and I think by and large, a lot of patients accept that sometimes things go wrong, they then expect someone else to have picked out the mistake within a reasonable time, right? So it's a larger question than if it's a houseman, will they be responsible by themselves? It's a much larger question. It's patient versus the hospital team in a sense.
Usually when the suit comes in, the junior doctors are not named in the suit usually. It's the consultant, the head of the Pengarah, DG, Minister of Health. It goes along that way.
So that means everybody is responsible, right? But they have a different role. So I think, yeah, we have to make aware that actually we are responsible to everything that's under us, basically. Okay, thank you for the answer. So the next one, I think is about consent. Being a culture variation in our society that is a close-knit family, uh, would you suggest also take consent from a spouse or a parent of a patient more than 21 years old for a procedure of surgery being planned?
Okay. Put it this way. The consent guidelines did not make arrangements for Asian society, but for Asian society, we cherish our family tradition. That sometimes conflicts with confidentiality. So the first question is to the patient. Do you want, first we have to ask the patient's consent, whether they want to share it. If they feel uncomfortable, if they feel unsure and they want advice and things like that, yes, we can invite immediate relatives to come in. But if they are okay and it is a sensitive issue, they do not want to share it, it is their confidentiality. If we invite somebody else in, then we are breaking our confidentiality bond with them. It shows that they in the future they will not trust us. So you have to ask the patients first. I agree. So my question usually, I seldom take consent now, but when I teach people and I take consent myself, then my last thing is that, number one, is there anything else that worries you or that you're concerned about this procedure tomorrow? Number two, do you want to discuss it with somebody else? Or you want to discuss somebody, bring somebody else to discuss it? And usually they will say, yes, can my wife? There are things sometimes which are sensitive, which they do not want to discuss with them. We cannot take it upon ourselves to be the judge.
Yeah, it's true actually. Being in, I'm not as experienced as you are, Dato', but I think sometimes they would like to discuss first, so before they agree to the procedure, like us anesthetists, before they would say okay to the anesthesia type of the anesthesia that we're going to perform to them. So I think that is a very, very good point that you have mentioned. We ask for the permission first. Maybe they also, some of them don't really want the other or the family members or to know about this also. Yeah, I think that is confidentiality is there. All right, so we move on to the next one. I think this is from our colleague radiologists, yeah. In the era of defensive and imaging dependent medicine, can Dato share your experience of medical negligence towards radiologists? Which is actually they are behind the scene,
Yes, I have not. My expert evidence have always been in anesthesia and intensive care, but radiologists, put it this way. I'm not so sure which defensive medicine you're referring to, but doing procedures in number one is procedural, number two is non-procedural. Most radiologists do non-procedural. We report, isn't it? So that is not an issue because of internet and things like that. That's provided for. It's the procedural radiologists that need to be a bit more careful. You have to be more defensive. I know defensive medicine is very important in interventional radiology, specifically because you die, you put a line in. I know some hospitals, they won't even touch it, they won't even put a line. They want somebody else to put a line, but they have been very out of putting IV line to put contrast and things like that. But even if somebody has put in the lines for you, you must make sure that the lines are correct. It's not bumped, it is not come out into tissue. When you give the dye, you must always ask the questions whether they have dye reactions and reactions to dye and things like that. And if you, the important thing is if you are asked to do an investigation, you must discuss, if you think there is a better alternative, to discuss with the person referring to you why they want to do this investigation. And when I was a houseman radiologist, I said, why do you want to do this investigation? I get very upset. I'm asking for an X-ray. Why you want to ask me for why I want to do an X-ray? But there are there's a case like Birch and University of London. The patient has an aneurysm, and they wanted to do an angiogram, and the risk of stroke in aneurysm is quite high. But down the road, there's a hospital which has installed an MRI. So they should look at it from the patient's point of view. I can do an angiogram, but it may have a stroke. So why didn't I refer to the hospital down the road? I can do MRI. So they did not consult back with the person who asked them to do the angiogram. Maybe an MRI can give you a better picture. So with interventional, there are many ways which normal physicians or normal surgeons may not see. There are things that you can do. So you have to discuss with them. Can we do this? It's better, it's safer, and things like that.
Thank you, Dato'. The next question.
Prof, sorry, could I just answer that? Because I think Charlene and I were just in the midst of a litigation where I was defending a radiologist. Okay, Charlene still carries on, but my client is now out of the picture, where there was a misdiagnosis of a shoulder fracture. It was a difficult image to see, but ultimately, Dato' Hassan spoke about the 4Ds, the anatomy of the 4Ds, the duty of care, the breach followed by causation. Now, just because she missed reporting it, the fracture was of the shoulder. She was then referred to, the patient was then referred to orthopedic. It was a question of whether the images also followed or was there just a report. So the difference is a radiologist makes a diagnosis but doesn't do the treatment. It's just a referral for the treatment. So when the treatment is done by another specialty, and there is a co-managing situation. So there would be more than one specialty involved in this process, and the causation would be for more than one specialty, not solely that of the radiologist, unless there is a situation of interventional radiology, as Dato' Hassan said. So we've seen cases where they're doing a biopsy and then something goes wrong in terms of maybe a lung biopsy and then there's a puncture. So it's a small risk, but it depends on that. Thank you.
Datin, we lost you.
Sorry, which part did you lose me at?
I think before.
Puncture of the lung.
At the puncture of the lung. So it depends on the consent. So it comes back to whether when taking the consent, there was a risk explained of a potential 1% risk of a pneumothorax in that case. So consent taking is equally important for radiology when you actually see the patient to do intervention. When you're reporting it, it's literally images, you don't see the patient. And a lot of people don't realize it. We had one MMC matter where the radiologists were all taken to task and only at the hearing did the complainant realize that radiologists do not see patients.
Yeah, I agree. Usually the radiologists don't really see the patient. It's only during the reporting. Yeah, Miss Charlene, do you want to comment about
Just a very short one, Prof. Yes, I think one of the only thing I'll add is that, look, especially when it comes to radiologists, and any other specialties, when there's a co-management of the patient, I think it's very important because we do defense work. The different specialties have to work with each other, right? So, for example, as a radiologist, if you are not certain, call up, whoever the treating doctor may be. Likewise, the treating doctor, if you're not certain, it could be an orthopedic surgeon, for example, and you're looking at the images and you feel, not quite right here. Call up the radiologist, because often what we don't want happening in court is that the defendants are pointing fingers at each other. So what you do actually is you are fighting the plaintiff's case for you. The plaintiff just sits back, looks at the doctors, and they're just blaming each other, and the plaintiff is like, this is brilliant for me. So as the right, Dr. Hassan is laughing because he was your expert in the case where when the defendants all have a united defense, there really is power in that. That's all I would add.
All right, thank you. That is a very valuable advice to all of us. Before we go to court, we must have a discussion among the doctors first. Then only we go. Then we can, have the same the wavelength or thoughts about how to handle the case. All right. The same doctors Dato was asking about advice or flow guide to doctors interested to taking up healthcare and medical law.
Oh. Okay. You can do it out of interest. You don't have to do courses and things like that. But if you really would like, I did it because my ultimate thing is to go and teach doctors. But when I started Masters in Law, Shanti was one of my lecturers, and she asked me specifically, why are you doing this course? It is not to career advance me, because I'm doing cardiac anesthesia, not many people are doing like that. But I told her very specifically, I said, I want to do medical law so that I can go back to university and teach doctors not to do mistakes when they come out. That was my main aim. If you're going to do that, then you go enroll yourself and learn about it. And in Malaysia, I did it in Malaysia because I inquired from the MQA if I did, because there are a lot of courses overseas, Liverpool, Manchester, and things like that. Edinburgh, things like that. But they say if you do entirely online, they will not recognize. That was at that time, before the COVID era. So I had to look for a course in Malaysia that offers medical law, ethics as a subject in this country. At that time, there was none. And Taylor's University was the first one to introduce it. And I became the first candidate. There were three of us. Three of us started the course. So I was the first batch of masters in law at that time. Now UITM has started it also. They have a master in ethics and medical law, which I lecture in the medical law area. So there are two universities in this country that offer medical law as a specialty for doctors to go and learn. UIA used to have a diploma in medical law by a prof, but I think somehow it got discontinued. So if you are interested in it, you can do it now in Malaysia, in this country. And it's good because when we do it in the country, we see local cases and we understand local cases better. And we have our counterpart, the Singapore Medical Council. We see the cases in Singapore, and we can compare how the Singapore have advanced their medical law compared to us in terms of guidelines and things like that. So we can, doctors who are interested in it can do it locally, or now they can do it overseas because of the COVID. Maybe the MQA may recognize 100% online courses and recognize that. But I do know of doctors in the Ministry of Health, like Dr. Hatta in Sabah. He did his in UK from a UK specified things.
Okay, thank you. I hope that we see more doctors will do the medical law in future with a lot of course being available nowadays. All right. So talking about the teleconference, I think there's a lot of question regarding that. One of it is regarding taking consent using telemedicine. A few of the participants asked this question, and I myself actually during the COVID era, we have one patient who's a foreigner that we have to do it online, and when I seek advice from even our uh, hospital management, they also have to look for it. It's not an easy, it's not a norm for us. So how would you advise on this?
Thanks, Prof, for the question. I think this is recording the consent. Is it advisable? Is it? Um, it's okay to record. I think it is fine, but just remember that, and I saw one of the questions that, what happens if there's no consent? It's always good to ask the patient. Okay, and I think as a healthcare practitioner, if the patient doesn't consent, I think it's good practice to honor that view of the patient. All right, but you can always put in your notes that requested for consent to record, patient did not agree. Now, with regard to a recording, remember it works both ways. So doctors always feel that it's good because the patients are always going to come and say something different. Now, remember, if you record the consent, it's also going to record things you said, which may not necessarily be appropriate, or things which you didn't say. Dr. Hassan was talking about omissions. So, for example, if you forgot to advise of a particular risk, which the court deems material or the patient says is important, and we review the recording and really there wasn't an advice of that, it can work both ways. But a general rule of thumb, I would advise all doctors, when you are doing telemedicine, even in your daily physical consultation, advise the patient as though you are being recorded. So you will never be surprised and you will always be on your toes. Yeah.
What if the patient? What about the consent? Because is electronic consent stand in court?
Is it valid?
Yeah, is it valid?
Absolutely, it is valid. There is a specific area of law where certain things cannot be signed electronically, but I'm telling you that consent forms don't fall under the exception. So it is valid. It will stand in court, Prof.
Okay, all right. That is a very, a good answer, because in the era of COVID, we actually there's to call the family members to come to consent for certain procedures. Sometimes it's very difficult because they are quarantined. They also patient under investigation, and we have no choice but to do an e-consent. So I think this is the time that maybe we should learn more about this, and then in our practice, I'm pretty sure in future there will be more.
Absolutely.
E-consent will come in. All right. Okay. So the next one would be, in the era of rampant usage of social media, and some of our colleague post patient face pictures regarding the stories in social media. Does it consider breach of confidentiality of the patient? Yeah.
Very simple. Absolutely. It absolutely is a breach. Unless you have specific consent from the patient, asking the patient for permission to use these images or any identifiable information. Sometimes you may not post a picture, but you may describe the person. And if other people are able to identify the person, you can be caught by the PDPA as well. Yeah. Okay, unless you have very specific consent. We've had to defend matters before the MMC where they have written, like basically the clinic has their own Facebook page. Okay, then they had either success stories or like the before and after pictures, that kind of a thing. You need specific consent. And if you don't have specific consent, I think you shouldn't. In fact, I think in one of the MMC guidelines, the title escapes me at the moment. I'm not sure if it's audio recording or confidentiality. It expressly provides that you cannot even use information or images of the patient, even if it is for education or research purposes. So I actually have some of my Facebook friends who are doctors and they mean well. You know, it's a case where, for example, the patient has fared really, really well, and they put the before and after photos, and it's a really good messaging, but you have to be very aware of confidentiality. Yes.
I would also like to say something about confidentiality. I'm not so sure whether it still happens now. In some government hospitals, in the intensive care, at the entrance to go to intensive care, they will write down patient's name and bed number. Now that is a clear breach of confidentiality. It's still, when I was giving my lectures, so my hospital still does that. So you see that even down in even in IJN, we used to do that when we started. You have a big board in front of the ICU, patient's name, bed number, and who's the doctor. Now we've changed everything to RN number, so it cannot be identified. Even in our operating theatre, outside the operating theatre, we have a screen. We say operating theatre 4 RN number, what operation going on. So that only the exact relatives know. Nobody else can know. So confidentiality goes a long way. We may miss all these things normally.
If I could just add also.
Yeah, sure, Miss
Yeah.
Hanti.
Just to add what Charlene was also saying, even if the part of the body cannot be overtly identified, there are prohibitions on publicity. And actually it goes back to the professional component of our professions, right? The confidentiality has to be something that conveys confidence in the profession. This is actually now a 21st century problem where we are all in a position where our professions are marketing. And I think this is where the problem is. And one of the issues that came up during COVID was when patients were in the wards and, under ventilators, you can't recognize who they are, or people were taking photographs of that. Now, it has not really become an issue in the sense of it's become a case or an MMC complaint. But the question has been raised, how are these photographs being even taken? Some of these people may have died later. Right? So you've got no complainant. Should the nurses or hospitals of that particular ward have allowed these photographs to be taken of these people in their sad final days or hours? And it comes back to our profession again. The medical profession. Medical profession is equally constrained by confidentiality. Yeah, the reason why you don't hear so many arbitration and mediation cases is because we can only speak about it in very general terms. Confidentiality is to be our cornerstone. Thank you.
Thank you. Okay, this is the other way around. This doctor was asking, he or she is working in emergency department, receiving a lot of call from public, and then asking for advice. And the patient actually record the conversation of the doctors. So what is your and then after that, if there is any complaint, what is your advice on this?
Thanks, Prof. All right, now let's just go step by step. Is there a duty of care that the doctor owes to the patient? Yes, there is. Okay, once you take the call, there's a duty of care, right? But let's also be mindful that the law is not very rigid. Okay, so what's the standard? The legal standard as to the standard of care, remember I mentioned earlier on, is dependent on the specialty of the doctor and the circumstances that the doctor is in. So if you're in A&E ward, you're in the ED, okay, it's already probably, depending on what time of the day, what day of the week, you know what I mean? And someone just literally just calls you out of necessity and it's an emergency. Rest assured that the law will take these factors into account, okay? So do the best you possibly can. Ask as many questions that time permits. And if you need to give a proviso, as lawyers will probably tell you, you need to make the necessary provisos. For example, minta maaf ya, Encik, I'm not so sure of your condition. Boleh tak kalau Encik datang ke hospital sekarang? Okay, nampaknya keadaan Encik agak tenat or something, whatever it may be. Okay, or ask more questions because sometimes patients, they may not know what information to give you as well. All right. So just be mindful. Then I'm going to go to the recordings. Okay. We've had quite a bit of this lately. Patients have just recorded, and then what they do is they will complain first, either to the hospital or to the doctor. And then once the doctor responds, then they say, you see, you're lying because, I have this recording and you said something else. Okay. Is recording which are taken without permission permissible? Either MMC inquiries or court? I'm inclined to say yes, they are. Okay. So just be very mindful, as I said, if as long as you are your doctor's hat is on, right? Just as long as you do the right thing, I don't think you need to be necessarily worried, right? So don't always second guess the person on the other line or the patient that's talking in front of you, because that might interfere with the treatment and management of the patient. Yeah. Sorry, Prof, did I answer the question?
Yeah. I mean, basically, you are responsible for whatever whatever advice you give to the patient or whoever, even the public was just asking for advice. So
Yes.
yeah, that
Yes.
sounds scary,
No, but take refuge that it's in the context. So, for example, if you go to court, right, and you say that it was a really busy day, you're A&E, you only had several seconds on the phone, I would hope that, and if you apply even the Bolam test, because there's a phrase that says, in the circumstances of the doctor, right? So all of that has to be taken into account. Yeah. So please don't be too worried, but yes, you have to be careful, but don't be too overly worried.
All right, thank you for the reaction. Yes, Miss Shanti, you want to say
Now, I was
something?
going to say that, in some circumstances, the call could be from someone who's not a patient. So there could be the good Samaritan argument also, because you're just trying to help what to do. So what Charlene was saying about asking the right questions, are you even talking to the patient? It could be someone who's talking on behalf of a patient. Then it's basically the game of telephone, right? You don't even know whether you're getting the right information. So a few qualifying sentences, exactly what Charlene was saying. Make sure that you close by saying, if you're not sure, come to the hospital. And, hopefully that will protect you as well.
Thank you. That is a very, very good advice, because sometimes we just, with the description from the patient, and it's very hard for us to imagine what is the situation actually, the real situation.
Yeah.
Okay, there's one question about termination of pregnancy for rape victims, especially those are mentally challenged and having intellectual disability. What is your advice regarding this matter? Any of the panelists?
Okay, I think I'll
Yeah, that's it.
with some part, and then let the rest continue. Firstly, when a person has a disability, they don't have the capacity to consent. That is the fundamental rule of it. So you either, if it's a child, you know that they don't have you need to get the parent involved. And if there's no parent, then the welfare department under the Child Act. So that is the process. Now, here is a child with a disability, but whether it's a child or an adult, that again is a question. Unfortunately, in Malaysia, we don't have a Mental Capacity Act, or we don't have any guidelines that will tell you exactly what to do. And a lot of times you're doing what is in the best interests of the patient, and it's like a joint collective decision. And whether continuing with the pregnancy will actually affect the person, will cause further mental distress, are they able to cope? So all questions that there probably will need to be open discussion with all the stakeholders. So there's no specific answer. You cannot just terminate just because somebody is mentally disabled. Again, it's a question of capacity. There is a movement within the disability community, women and girls with disabilities, to say they have got the choice of deciding whether they can have children of their own. There are those within the blind and then the deaf communities that say their parents don't trust them to have children. So again, it is very much depending on the circumstances of each case.
Any other panelists would like to comment?
No, I think Anil has captured the point. I was just saying that right now, our colleagues in Medical Legal Society are speaking on this exact topic in another forum, coincidentally.
Oh, okay, right. Okay, the next question would be, I think, to Ms. Shanti. The question is, can you explain what is mandate
Oh,
actually?
sure.
And is it compensation?
So a mandate is the power to be able to discuss and make a decision. So when you come, okay, just to put it in a different context, when you deal with lawyers who come into a mediation or a corporate party, so let's say the insurer's representative, in order for them to be able to say something, they have to have permission from their claims manager or the department that approves. So that is called the mandate. So if you come just to chit chat and you have no mandate, it irritates everybody who has spent the time and effort to come, wanting to make a decision. So you must come with authority to be able to talk, authority to be able to make some decisions. Even if it's limited, it's okay, but you must be able to come authority to make some decisions. That's what a mandate is.
All right.
Right.
Okay.
So that's
Can I just add on the mandate bit? This is what I sometimes experience in departmental meetings and heads of departments and things like that. When it is a meeting to have a decision to be made, the person attending it must be able to make that decision, whether he's the head of department or not head of department. Therefore, I remember one chairman asking, I was representing. First opening statement was, this is a decision making. You're not going to discuss anymore. This is a decision making meeting. All those present should have mandate or be in a position to give their decision. If you are not, do not have the mandate, please leave. So mandate is you have the authority. After the meeting, you have the authority to say, yes, I agree, I disagree, I do not agree, whatever it is. You cannot go back and say, can I bring it back to my department? That is not mandate.
and usually for mandates, normally the mediators or whoever's organizing the mediator will make sure that the parties know this, so you don't get surprised on the day of mediation. So there is a method in that process where beforehand we will make sure that parties get the mandate so that on the day of, say, a mediation, there's not wasted time.
Yeah, I think that's fair, isn't it? If you can't make the decision, you come to the discussion. There's no point. Yeah. Okay. So the next question, I think, is still for you. What medical negligence cases can be solved by mediation?
Okay.
Cases or cases that cannot?
So quick answer to that question is anything that has a criminal element may be excluded from the mediation basket. Right? Give you an example. Sexual harassment, question mark, whether you can mediate it. Okay, so I say question mark because there are different schools of thought that think that sexual harassment can be mediated. But if a medical negligence, for example, because abortion, for example, is illegal in this country. So if someone would ask me, can you mediate something where one person is arguing that it was an abortion, I would say this might be a bit difficult, right? Because if it has criminal elements, there's no confidentiality. The whoever is involved in that. So criminal matters out of the child abuse, all that is out. But anything to do with anything else, from cerebral palsy to wrongful removal of an uvula, of a tooth, everything can be mediated if the parties are prepared to sit down in a room. So I will tell you, for cerebral palsy cases, um, the normal length of a mediation is about 4 days, either stretched over a few months, because there's work that needs to be done before the parties are able to sit down. You don't have to go to court. I think the record is $10 million CP baby case being mediated and resolved. So it can be, so pretty much every case can be.
Okay. Thank you for that. The next one, we came back to the documentation. I think they are really worried about this. Is there any specific time or time period that we should take in consideration as per retrospective entry? So that means, can we do it like a month later, or so? So is there any specific time or any advice on this?
I think we will have to go with the golden rule, as soon as possible. And if you are, as Dato Hassan pointed out, something very, very important. If your priority is your patient, not your defense to potential negligence, right? If you leave your patient just to write down notes, that in itself is negligence. So it's all within common sense and reason. If you come back 8 hours later after having worked on the patient and you just say, time spent in OT, time spent sending the patient over, you can validly explain the 8-hour delay. 1 month, a bit susah. Unless my colleagues have a different view.
I think the reasonable way to do it after you have finished resuscitation and settle the immediate problem, and things have been, look at the patient has been, all the resuscitation is over, and then things are as soon as you can leave the patient. I think that is all. Should it be a reasonable time? Because sometimes
yes.
resuscitation for hours for the patient.
Yes. Yes. That would be very reasonable. You don't expect them to do it any earlier.
Okay.
The golden rule that Shanti spoke about was also as soon as possible, because your memory would serve it as soon as possible. It's contemporaneous. Something a month later will attract this thing of whether it's an afterthought, whether you've gone back, looked at it on a wider scale, zoomed in and say, I should have done this, and then written in something that really didn't happen.
Actually, with the aging process also, we sometimes tend to forget a lot of things.
Yeah, including what we had for lunch.
Yeah, that's why I was saying, soon after you have resuscitate the patient, you should write the documentation. Okay. There is a questions about, okay. About consent. About the age of consent. May I know, for children less than 18 years old and she got married, who will be the right person to give consent for the patient?
Dato Hassan is the pro. I'm going to leave it to him.
We were waiting for our consent king to speak up.
Definitely Dato Hassan.
Okay. In this country, age of majority is 18 years and above. If you are unmarried, but if you are married, it can be below 18. And in some states, you can marry when you are 16 and above. Therefore, the age of consent, 18 and above, is for unmarried people, especially women. But if you are married, you are under 18, you are autonomous.
Okay, that's something new to me also. I maybe if I have problem with consent later, I will just call you, Dato, and ask what is the right way to do this.
The problem is when we have girls who are pregnant under 18, unmarried, it means their parents have to give consent. But the problem is when they deliver and they have a child, they are under 18, they are unmarried, and they have a child, and the child is usually in a young person. Usually, children will have more problems during delivery, and the child will have congenital things like that. They're premature. So, who gives consent for the young one? That is the issue in this country.
Wow, that's going to be very complicated. Yeah. So I would say maybe we should have some advice from our legal officer, isn't it, regarding this? Because we also have to protect ourselves in order to get consent for the procedure. It's not easy. Okay, I think this is going to be maybe a few last question that we can take. Yeah, there's a lot of question basically. May I know who will hire a mediator in a medical dispute? How will the charges be? And in a usual scenario from your experience, how has the medical dispute resolved usually, and how long usually will be the discussion and conflict to go on?
Yes,
I
the
think
multi parts to that question. Very
yeah,
quickly.
I think the second part you have already answered just now, a little
Yeah.
bit. Maybe the first one,
First
who
part.
will
All right.
hire the
So
mediator?
actually, anybody can start the conversation about mediation, but typically plaintiffs, patients who go to plaintiff lawyers may not necessarily be advised to consider mediation unless the law firm is a mediate preferred or a mediate first law firm. So, like I said, anyone can suggest it. But what has happened in the past is when they did defense work with doctors and all that, the insurance companies who have been supportive of swift settlements do allow for the appointment of the mediator. They pay for the appointment of the mediator as well, because it takes one important part out of the equation. Because when you have an unhappy patient who has already spent loads of money on hospital bills, the last thing they want to do is spend money on a mediator. So this needs to be big picture thinking by hospitals and doctors to say, okay, we believe we have a strong case. We will get you into the room and we'll explain the situation. And this has worked several times where the hospital has said, we will bear the cost of the mediator. Everyone come to and have a discussion. And there is no moving the mediator to persuade the patient, nothing. It's a very authentic process. So where it has been used, in my experience, hospitals have borne the cost. Hospitals and doctors have borne, the insurers have borne the cost. Outcomes, I must say the outcomes of the mediations I've been involved in, and this is not necessarily in court, but these are ad hoc outside using really properly trained mediators, has been excellent. So both in from the perspective of as a mediator as well as a mediation advocate. In fact, there was one very quick story which I wanted to share, which was involving stillbirth. The opening letter from the plaintiff law firm was for $5 million, right? Then it went down to $1 million. And at that time, the insurers unfortunately said, yeah, this is just emo, right? And refused to do anything, essentially telling the hospital and the doctors, let's wait for the suit to come. But the hospital, I must say, give credit to them. They were quite wise. They said, no, we want to resolve this matter. And we acted as their mediation advocates. We organized the whole mediation. We recognized that $1 million was just really emotions on a piece of paper to be handled in a mediation. We appointed an excellent mediator who was able to navigate the parties as well. We thought it will resolve in 2 days because of the high emotions. This couple had taken 3 years to conceive this child on account of something that happened, including the missing CTG, the child's heartbeat. The child had gone through distress, the baby had gone through distress, missed stillbirth. But we were able to resolve it within the same day itself. And there was an apology by the doctor to the patient, which happened, and it didn't get recorded in the settlement agreement as well. So there's so much. And when I came out, the hospital asked me, why don't you all do this more often? So I said, get interest to have a proper system to put this in. It cannot be on an ad hoc basis, because this one was inspired by the hospital, not insurers. Sad to say. So I foresee that actually on the ground, it does work very well.
I think it's a very, very good to know this, because sometimes we are not aware of these kind of things can be done. Okay, I think this is going to be our last question, and maybe for the rest of the question, maybe we will address to the panelists later, and maybe you can email to you, and maybe we can email them back to the participant. This is actually happen quite often in the hospital. do not resuscitate order for critically ill or advanced cancer cases. There's a lot of this term has been used. If it's prescribed by the managing doctor, but family members of the patient disagree and insist of continuation of care and treatment, how would we handle this? And any of the panelists would like to take that? Dato? Yeah.
Okay, right. DNR is usually a consultation between the patient or the patient's proxy with the primary physician. If there's agreement, only then there's DNR and there might be witness. Some hospitals would have specific forms for this already. Some private hospitals have, I'm not so sure about universities or government hospitals. But I do know in private practice there is a DNR form. And the patient actually signs, or if the patient is given the mandate to somebody else to do it, then that person is the proxy and sign. It must be a legal letter. Otherwise, you make a decision without the patient knowing it, without the relatives knowing it. That means you're doing the decision on your own, which is not right. And a lot of times I've seen this, the primary physician say DNR, and then patient has cardiac arrest, code blue announced, and anesthetist comes on the list, comes into the OT or in the ward, and the nurses say DNR, but there's no DNR forms inside there. That is not a legal issue. That becomes a legal issue. Okay, DNR is a legal issue. So from my point of view, like I said in my last lecture, intensive care, resuscitate everybody unless there is a DNR. If you accidentally resuscitate later on, there's a DNR, it's okay. If somebody says to you DNR and you do not resuscitate, the patient dies, and then there's no DNR letter, then you're in trouble. Patient can leave later on. Your job is to, if the patient leaves, you can retrograde. But if the patient dies, you cannot make the patient leave again because there is no DNR. The assumption is resuscitate unless there is legal DNR.
Any other panelists would like to comment?
Oh, if I could just add just only one thing. The Malaysian Medical Council actually has a section that's dedicated on this topic in their guidelines on consent. So I'm just going to ask all the doctors in general, please read through the consent guidelines. They're very long, but they're very easy to read and very, it touches on a variety of issues, including consent for minors. It also talks about people who are unmarried, who are below 18, all that. Please read through the MMC guidelines on consent. There's a specific section on this, by and large, exactly what Dr. Hassan said. And just remember, from a legal point of view, it needs to be, the advance directive needs to be so specific to that particular circumstances. So the minute there's a change in the circumstances, it can be argued that it's no longer valid. So if you choose to act on any advance directive, please be very, very sure. Yeah. If you are in doubt, also remember that the courts are also an option to go and ask the courts for how you ought to treat the patient moving forward. That's all. Thank you.
All right, thank you. Our Society of Intensive Care also recently has come to guidelines about advance directive, and to us it's quite clear. But however, we are not we are not well versed with the law. Sometimes it's still certain things is unclear, but we are trying to understand how all this, whether how should we manage this DNR.
Sometimes we lawyers also are not sure, Prof. You're not alone.
Because that's why I've been reading it a few times, and some of the clause I said, oh, I really need to read or ask, from the experts, about this matter. All right, so there is a few more questions. I think maybe we will address it to the panelists and email to the respective doctors who's asked for this. I would like to thank all the panelists, Datin Anik, Kor, Dr. Hassan, Ms. Charlene Chin, and Ms. Shanti Abraham for excellent session. and you know, to open our eyes towards a certain aspect of the medical legal. I myself learned a lot, and thank you so much for spending your Saturday with us throughout the from morning till I think it's almost lunchtime already, you know. So thank you very much. We really appreciate the effort and all the time spent with us. We hope that this is not the last time we're going to see all of you. We would like to invite you again for maybe for our next program. Okay. I would also like to thank my dearest postgraduate Deputy Dean, Professor Nur Laila Mustafa, and also Prof. Zarina Abdul Latif, the Chairperson of Postgraduate PPD Program, Prof. Dayang Anita, Prof. Emilia, and all my fellow colleagues, the committee members of the postgraduate PPD for our masters. This is the first time actually we done this program. So we hope that we will improve the soft skill, the professionalism, and also communication. That's been stressed a few times during this webinar among our masters trainee. And hopefully there will be better knowledge, and they have more information compared to us. I have never been taught this during my medical school days, and in fact when I was doing master, there's none, like Dato' Hassan said. So but recently, yes, this has been a good progress, I would say, from the program. And I would also like to thank the Secretariat who has working tirelessly since the planning of the program. We have been, you know, behind the scene. Thank you so much for the Secretariat. And last but not least, the participant. Thank you for attending this webinar. And we really hope that this will help you to build your soft skills and your professionalism development in your future career. And with that, I would also like to remind the participant, please fill in the assessment form of the program in order to help us to improve the program in the future. And don't forget, you need to write a report according to the department from the, you know, from the session today. The QR code for the CPD point will be shown at the end of the session, and please scan it. And for the UKM staff, the QR Smart Attendance also is available at the end of the webinar. I would like to apologize for the some of the technical glitch of the webinar. I'm pretty sure all of us is still learning and try to adapt with the new norm. It's not easy. And my recent experience with the Anesthesia Congress is not, is really not a good experience for me. I nearly, I think Dato' Hassan is there with us. It's not a pleasant experience, I would say. But anyhow, we managed to overcome it and, you know, to be better in future. With that, I would like to wish all of you a very good weekend. Stay safe, and thank you everybody for a very fruitful session. Thank you everyone.